Okay, it's January 28th, and this is the second lecture of this week. I've already posted a lecture and a discussion board forum for this week. The discussion board forum being the one over litigation. This time around, we're going to talk about arbitration, which actually came in Chapter 3 right before litigation. And we're also going to talk about Chapter 4 about the international sales of goods. You have two choices this week for your one-page response paper. The questions are a little bit more involved this time, so if you need to go over length just a little bit, that's perfectly fine. Don't get too hung up on meeting the bottom of the page exactly. The two choices that you'll have are between arbitration and the CISG. So I'm going to start by talking about arbitration just a little bit here. First, as I mentioned in the last lecture, generally, alternative dispute resolution of one form or another, whether it be mediation, arbitration, or some other type of neutral decision maker, is far preferable to litigation in international business. The international business structure just does not support litigation very well. Litigation is slow. It is done in domestic courts in specific countries that might be biased towards whichever party to the transaction is located in their country. It often has any number of different rights of appeal, which can actually be a detriment to companies doing business abroad because they need efficient decision making in order to achieve the results that they want. Alternative dispute resolution is generally faster, generally cheaper, and generally more efficient. That does not, by any means, mean it is always the best option, but it is usually the best option, especially when we're talking about the normal or routine business transactions between private distributors and sellers in different countries. Okay. There might be some specific topics where you might prefer litigation over arbitration, especially if you're in the banking industry or if what you're selling happens to not be a good or service, but instead happens to be something different or unique like land or stock in a stock market, okay? Bonds, treasury bonds, those types of things, that's all quite a bit different. But when we're talking about goods and when we're talking about services, generally arbitration is going to be far more beneficial because of its efficiency and because it's slightly cheaper, usually. You also have a backstop against partiality. In litigation, if you're in a domestic court, either here or somewhere else, one of the parties is probably foreign to the court that's hearing the case. And that creates, in the minds of some, a level of bias, right? Court, especially abroad, might be likely to hold for the company that is domestic to them, simply in order to remain on the good side of their local entities, to side with their local entities. There are two main types of alternative dispute resolution: mediation and arbitration. Mediation is basically like arbitration light. It is the low-calorie version of arbitration. It is voluntary, just like arbitration is. All alternative dispute resolution is voluntary. No party can ever be forced to do it, although it is customary in international trade. You would be the odd duck doing global business if you were the one holdout that did not agree to some form of alternative dispute resolution. So while it is voluntary, it is generally a business expectation, and you would be hard-pressed to find buyers and sellers that do not frequently agree voluntarily to either mediation or arbitration. Like I say, mediation is arbitration light. It is still impartial. Voluntary, secretive in terms of the press can't get a hold of the proceedings very easily. They're not made public. A lot of countries have open records statutes. The United States does, for example. And so some of that information, if you were to go the normal litigation route, might be accessible to the press or to the public, might result in exposure of embarrassing business dealings or conflicts within the company. And that can create some bad PR. As good managers, we all worry not just about the legalities and our contracts, but also our public image, which might be important to sales and future contracts, right? In mediation, the parties, this is the important part of mediation. The parties still reserve the right to seek arbitration or litigation if the mediation falls through. Okay. And this means that mediation sometimes is a waste of time. If you lose in mediation and you can still go sue, then what good was the mediation, right? Mediation is best used for minor transactions where a person it would be unusual for them to care so much about the outcome that they would then go that next step. But really, if it's not a minor transaction, mediation generally is not the best route because it's easily overturnable, and courts might not recognize the result of a mediation and may then go ahead and enact their own judgment, separate from whatever mediation already took place. So not generally recommended except for low-level transactions, and it's not even particularly common. So that leaves us with arbitration. Arbitration is generally the best method of dispute resolution in international business. Once you agree to it, you can't back out. That's one of the selling points of arbitration. The fact that you know that the other party, who you might have a dispute with, can't just walk away from the arbitration and then go file a suit in some court somewhere. Okay? So once both parties agree, and you generally agree through a contract, so if you're selling a product to a buyer abroad, you write out a contract. In that contract, you'll have a choice of law statement, right? Some provision in that contract that says how you expect any disputes that arise under that contract to be resolved. Generally, that's where you're going to find your arbitration clause, okay? And the good thing about arbitration is, across the globe, courts generally respect and trust arbitration as a method of dispute resolution that displaces or takes the place of litigation, which means it's binding. It can be binding in court. If the loser in an arbitration battle goes to file a claim in a United States federal district court, the federal district court will look at that arbitration, and so long as it's consistent with public policy, and so long as it was a fairly done arbitration, they're going to respect the result of it. And they may even help enforce the result of that arbitration decision domestically. So if the arbitration decision said you owe the other party damages, or you owe the other party specific performance of the sale, the domestic court may very well put an injunction on you, making you do what that arbitration said you should do. Okay, so it is something that takes the place of litigation. The courts won't let you litigate if you have a proper and binding arbitration. The selling point already mentioned is that it levels the playing field. That's the phrase used in the book, levels the playing field, because the courts of one country might have a bias. And generally, when you agree to arbitration, you agree to arbitration in a third party's country, and with judges or arbitrators that are not from the countries that the parties before the arbiters are from. So an arbitration involving a dispute between a United States company and a Canadian company could take place in Japan. No problem, no bias, right? Obviously, arbitration operates on a principle of neutrality. So you have a lot of the same rules as you would have in litigation to ask someone with a conflict of interest to recuse themselves. Generally, the parties in an arbitration will agree to who gets to hear the case by nixing certain potential arbiters until they land on a final list that doesn't include the ones that the parties specifically chose to exclude. Another good thing about arbitration is the rules are more simple than litigation. You don't have an amalgamation of different nations' laws coming into play. Some countries don't even have very well written laws or even a body of case law that you can look to for precedent. But arbitration rules are generally published in multiple languages. Depending on the tribunal that does the arbitration, your book includes lists of different potential arbiters. Those rules for arbitration are easily accessible, sometimes as simple as a few clicks onto a website and then changing the language. The pretrial phase is faster in arbitration, and this is important. For every dispute over the terms of a contract or whether a party was a bad actor to an agreement, there's a pretrial phase called discovery. The discovery phase is the phase in litigation or arbitration where you collect the information. So if the question is, did the parties intend to form an agreement? Well, you might want to look at the history of their negotiations, their emails back and forth. Collection of that information and that history is called discovery. It's part of that pretrial phase, and in arbitration, discovery is more limited than it would be in litigation. In other words, you are wanting to pick up the pace, collect information quickly, maybe not deep information, metadata, and emails going back years, right? Some witness testimony and affidavits. No, let's make it simple. The rules will lay out exactly what can be collected during the pretrial phase. Maybe it'll even limit some things from coming in because of the efficiency. But often businesses want efficiency. So it shrinks that pretrial phase to something that can be done quicker. It's less extensive. In arbitration, just like mediation, the process is private. Generally, there are no publicly available records. To the extent that things become public, it's not going to necessarily be the details of the arbitration itself. Maybe the outcome may become obvious to people, depending on whether a payment was made as a result of a bad act, or if a domestic court was needed in order to enforce the arbitration. But beyond those things, the substance of the debate back and forth during the arbitration itself, as well as the information collected during the pretrial discovery process, would not be available to the press, would not be available to the public. And so, for obvious reasons, some companies might prefer that. You do generally hire attorneys in an arbitrative process. But because arbitration is more predictable, sometimes the cost is less, especially if you hire attorneys that are already used to the process and don't have to brief themselves on the nature of how things are done in an arbitration court. Usually the fees are lower. There are more flexible evidence rules. This could be seen as both a benefit and a detriment to arbitration. The benefit is you don't have to waste your time worrying about what evidence is admissible, whether it's hearsay, whether it's evidence that's irrelevant. Generally, in arbitration, you'll just let it in and let the cards fall where they may, okay? Where in formal litigation, especially in the United States, you might spend half of your litigation time arguing over what evidence is admissible and what evidence is not admissible. And part of the reason is those records eventually become public. So what's admissible is very, very worrisome to people. But in arbitration, the records aren't ever made public anyway. So who cares whether information that comes before the arbitration panel is hearsay? Who cares whether its relevancy is at stake? Let's talk about it anyway and see what happens, right? It makes things simple. It makes things less complicated. Usually there are very limited appeal rights. In the United States, if you're in federal court, there are 3 levels of litigation. If you lose at the district court level, you can appeal to the circuit court level. And if you lose there, maybe appeal to the United States Supreme Court. But in arbitration, usually you have one decision-making panel and maybe a appeal option for actual mistake in the processing of the claim. Not appeal on the whole case altogether. So you have limited appeal rights, and that's seen as a plus in arbitration because it means there is finality to the decision, that the The prospect of an appeal totally changing the outcome is not continually hanging over the heads of the parties for a couple of years until there's some other body that then renders another decision that the previous decision was either kept in place or overturned. Instead, arbitration makes it simple. One decision, one time, final decision. Okay. Most international business contracts have an arbitration clause, so just know that if you plan on doing business internationally, even very closely, United States-Mexico type of arrangements, arbitration is still the in vogue way to go. And we've already talked about some of this, even back when we were talking about intellectual property. Remember the World Intellectual Property Organization that was in one of our hypotheticals. That's also an arbitration organization, right? They would be the arbiter of intellectual property disputes if you're a party to that treaty. Similar arbitration organizations exist for different subject matters. So intellectual property, the WIPO. If we're talking about construction, then there might be a separate arbitration organization. International cruise ships have an arbitration organization. Okay. Despite it being less costly than litigation, arbitration can still be costly. I would take a look at the information in your book about the costs of arbitration, where it talks about how for a case where there's $1 million at stake, the fees might have been up to $40,000 just for the attorney's fees, and then another $20,000 in administrative fees, adding up to something like 6 or 7% of the total amount at stake being covered in court costs and attorney's fees. If there's less money at stake in the arbitration, let's say it's a $100,000 arbitration, there's evidence that shows in your book that the cost of arbitration might add up to 15% scraped off of the total of the transaction at stake. So $10,000 or $15,000 in fees for a $100,000 dispute. So despite arbitration ostensibly being less expensive than litigation, there is still a price to it. So let's talk about some other disadvantages, since we've mentioned the obvious costs. The losing party not having an appeal route can also be seen as a disadvantage. It means that if a mistake were made by the arbitration panel, or the arbitration panel was incompetent, or the arbitration panel was, it turns out, maybe a little biased, you don't get to argue that to any appeal body. You just have to live with it. So that could be seen as a negative to arbitration. The limited discovery phase that limits the amount of information that might be viewable by the decision makers, that could be seen as a negative, especially if you're in a very complex dispute that ranges over a period of years and involves a lot of witnesses and evidence and email records and data history. That could become a problem. Some people see the admission of hearsay evidence and irrelevant evidence as unfair. And with less sophisticated rules of evidence, which are put in place for the sake of efficiency, you might sacrifice a little bit of integrity. And information might come in that causes bias to be created in the minds of decision makers. What's to stop one of the parties from bringing in an irrelevant discussion over the tawdry affairs of the CEO of the other company? Does it change their mind, the decision makers of the arbitration body, that he cheated on his wife? Well, if that information is admissible, right, because we have more relaxed evidence rules, then, potentially that might affect the outcome. I would say probably more overblown than we might think, but some folks might get worried about that. Less sophisticated parties are at a disadvantage in arbitration. Part of the reason here, and what I mean by less sophisticated, are smaller companies that don't do as much business abroad and aren't used to going to arbitration bodies to settle their disputes. Their lack of experience means that they haven't learned all the players, they haven't learned all of the arbiters, They haven't learned the rules as well. They might be working with attorneys that are just sort of learning them for the first time themselves. Where a bigger company that's more sophisticated, arbitrates all the time, it might have hired a firm that does this like clockwork, and they know the rules like the back of their hand. They know the exceptions to the rules and the exceptions to the exceptions to the rules. So it does put a little bit of a disadvantage on less sophisticated, less organized, smaller companies. And then the last disadvantage to arbitration: there is no precedent created in arbitration. The decisions might be binding, but they aren't law. Okay, so as we know from common law systems of government, decisions by courts can be looked to by future courts as a guiding inspiration for those future decisions, right? Maybe even as binding law on other courts. Not so with arbitrations. With every arbitration, it is a brand new case. You don't have to look at previous arbitrations, and in fact, you might not at all look at previous arbitrations in order to see how you should come out on an interpretation of a contract provision or something else. All right, so that was our discussion of arbitration. Hopefully that information might be somewhat useful to you in answering your one-page response paper if you choose option A. If you're choosing option B, let's go ahead and talk about the Convention on Contracts for the International Sale of Goods, the CISG. This is about sales law. The CISG is about sales of goods, not sales of anything else. Okay, so we're not talking about real estate or stock or patents or bonds or services. We're talking about tangible property, usually tangible property in packaged form. Maybe we're talking about steel pipes. Maybe we're talking about Dixie cups. Maybe we're talking about automobile tires, okay? Physical objects that might be bought and sold between nations. As you might imagine, that comprises an awfully large body of international trade. Most international trade is the buying and selling of goods. And importantly, 70 countries, comprising 2/3 of all world traders, have agreed to the CISG. So the Convention on the Contracts for the International Sale of Goods is a pretty big deal. We're going to be referring back to it at multiple points over the course of this class, because we'd be remiss not to discuss it in some detail in a class that's literally over international business law. So let's define sales law real quick. This is the law that governs contracts for either present or future sale of goods. So if you are a business entity making a contract either as a buyer or a seller of goods, either presently, immediately, or at some point in the future, then the CISG might govern that agreement. In other words, the interpretation of that agreement, the determination of whether there was a breach of that agreement, whether an agreement existed at all, might all be determined under the rules of the CISG. Okay? Now, the CISG is important because it's part of this evolution of the unification of law. As merchants did business going back to almost ancient times, they developed their own system of law before governments even started enforcing these things. They would stop buying and selling with a trader that didn't follow the so-called law merchant. Okay, and this slowly developed into English common law, and even in the United States today, unification of law has been a big deal, even beyond the buying and selling of goods. We have unified our contracts principles under the Uniform Commercial Code, the UCC. We have unified our law on marriages and divorces across many different states. So part of this is just to make things more predictable and to make the states less different so that people will know what to expect. We've even seen some unification of criminal codes, depending on the topic, especially drugs. Another important thing, I already said 70 countries are party to the CISG. This also includes the United States and Mexico and Canada. So all three countries in North America through which an awful lot of trade happens. Tariff-free because of the North American Free Trade Agreement. This is particularly relevant to the United States. What are the requirements of the CISG? Well, it has to be for the sale of goods. The parties, the two nations that might be party to this sale, both have to be ratifiers of the CISG treaty. Okay, so the United States doing business with a buyer in Mexico, CISG would apply, right? Maybe not if it's with a country that's not a party. Both nations have to be parties. It's not enough for just one of the two nations to be a party to CISG for it to apply. For a illustration of which countries have ratified the CISG, which if you look at the option B question, you'll see that this list comes into play. Look at illustration 4.1. It's called Exhibit 4.1 in your book, and that will give you a list of the countries that have ratified. You can still have choice of law provisions, so you are not mandated or required to have your contract with a foreign entity to be governed by the CISG. Instead, it is in effect in the absence of some other agreement, a choice of law provision in your contract, say for example an agreement to use arbitration, right? Well, then arbitration would win if it was specified in your contract that that's how you wanted your disputes settled. But even in arbitration, the CISG comes into play if it's a sale for goods, because very often what you're agreeing to when you agree to arbitration is arbitration that uses the CISG rules in the arbitration process. Okay, so even if you're choosing that, CISG is still relevant, even if it might not be mandatory. It depends. It just depends on what kind of arbiter you want to use. Do you want them to use their own rules? Do you want an arbiter that will just use the CISG? Or do you want to litigate? Okay. So don't forget that you still have those choice of law provisions. That's in Article 6 of the CISG. Things not covered. Well, services aren't covered. Certain types of goods, specifically consumer goods, so like soap, for some reason has not been covered by the CISG. Goods sold at auction, so no auctions. We're just talking about straight up buying and selling for consideration. So I give you money and you give me automobile tires. No auction. That would be CISG. Anything involving an auction is not. Stocks and securities, certain large goods like ships and aircraft are not covered by CISG. Electricity has been determined to not be a good. So if you are a electricity co-op and you're building power lines and you build them across international boundaries, you're not covered by the CISG because it's not the sale of a good. Assembly agreements. So I agree with a company in Mexico that you will assemble bicycles and then you'll send them back to the United States. That's not qualifying as the sale of a good. Contracts that are for both goods and labor, but are mostly labor, aren't covered by the CISG, even though they might include some goods in the contract. And then sales of insurance specifically for death or injury caused by goods, not enough of a relationship to goods to be covered by the CISG. 4 rules for contract formation. This is not necessarily specifically in the CISG, but it's true at common law, and almost every court's going to have these rules for contract formation. So rule number 1, mutual assent of the parties. A mutual agreement by the parties that you intend to be bound by a contract. Part 2, a bargained for exchange, usually goods for money, but it might be goods for goods. That's could still be covered by the CISG. Goods for services may be covered by the CISG as long as there is a bargain for exchange, which is also called consideration. Okay. Legal capacity and agency. This number 3, legal capacity and agency is, well, this is another way of saying that you have to be capable of being a party that may form a contract. So you can't be a child because we don't let children make contracts. So over 18, sure, you have to have legal capacity. So you have to be the authorized agent of your company to make international contracts. If you don't have agency, maybe you're a low-level employee that shouldn't be doing that in the first place, then you might not have a contract because you weren't authorized. And then number 4, the last rule on contract formation is it must be a legal exchange consistent with public policy and public law. So a contract for the sale of an illicit substance, for example, you're not going to be able to seek arbitration or litigation under the CISG because the CISG will say it doesn't apply to that situation. Okay. The writing requirement. This is interesting and unusual, and so I want to mention it. In the United States, not the CISG, just in the United States, we have a contracts code called the UCC for the buying and selling of goods. It requires for any contract that involves an amount of over $500. So if I'm selling you a coffee cup, but it's a really expensive coffee cup, I'm selling you a coffee cup for $500, I might have to write out a contract for that sale, okay, if I want that transaction to be governed by the UCC. And the UCC would require that. CISG is different, okay? The CISG, Article 11, specifically says that it is not required that contracts be written, okay? That might surprise some folks, especially in an international contract, which, I mean, look at the size of our textbook. International contracts aren't easy. There's a lot of moving parts. And yet, the main body of law that covers most international business, not just international sales of goods, which is what it's about, but most international business is the selling of goods. So our main international treaty that governs this says you don't even have to put it in paper. Kind of astonishing, right? Specifically, let's keep in mind, though, that while there are 70 parties to the treaty, there are a few parties that have omitted this specific article from their adoption of the CISG. So check your book. There are some specific countries that say, we don't care what everybody else thinks. Our version of the CISG requires a writing. Okay. The United States is not one of them. We're a party to the treaty, and we still don't necessarily require a writing if it's going to be governed by the CISG. Okay. So what does that mean in the real world? What that means is if there's a dispute over your contract and it's not a written contract, then if in the process of trying to figure out that dispute and see who's right and who's wrong or who breached the contract, in the course of litigation, they might look at your past dealings, they might look at your negotiation process, witnesses to the agreement, because you don't have it written on paper. So they might look at all those other things in order to sort of invent what they think the agreement would have looked like if it were written down. So obviously that makes things rather difficult. You always want to write down your contracts, boys and girls. It's kind of common sense, but it's not necessarily required. All right. Some countries recognize digital signatures. Again, this is only a handful of countries. Take a look at the countries listed in your book under the section on digital signatories. The United States is one of them. We recognize digital signatures, not just in the CISG, but all contracts we recognize as long as it's a reliable form of making your mark on the document that's unique in some way, then it could be electronic. Some of these contracts are signed with numbers, such as a specific code that's registered somewhere. Sometimes it's a stamp, electronic stamp. But the United States is one of the countries that recognizes electronic signing of contracts. Some general rules of contract interpretation. not specific to the CISG, but includes the CISG for all essential purposes. A written contract is generally referred to as an integrated contract, which is another way of saying any contract that is not written is not integrated. And so in any body that might still be willing to consider a contract that's not written, not all of them, UCC would be an example if it's the sale of a good over $500. But if you are before a body like the CISG that's willing to look at a not written contract, they will take into account the whole chain of negotiation and the conclusions of those negotiations. If you have a written contract, but it looks like a draft version, or it says it's a draft version, that does not qualify as an integrated contract, which is another way of saying the court might not limit their discussion to that document, and they may reach beyond it to look at other things. Otherwise, if you do have an integrated contract, then the peril evidence rule generally applies. What is the peril evidence rule? If you read this in the book and thought it meant parole, you're wrong. It's pronounced peril. It's not even a word that Microsoft Word recognizes, and when I type it down, peril, P-A-R-O-L, it puts the red squiggly line under it. But it is a real word, I promise. It's a real word in your book. It's a real word in international law and contract law. And here's what the peril evidence rule is. You may not consider in court any evidence that goes beyond the document itself if you have an integrated contract. Now, let's get more specific about that. This means that if you have a written contract, and it's not a draft, it's the contract, it's an integrated contract, the court will not look beyond that document in order to modify, contradict, or otherwise offer more perspective on a statement in the contract. They will not. The only way they would let some information in consideration beyond the four corners of the document is if there is an ambiguity in the document that can only be clarified by looking at something beyond the document, like a witness statement or prior negotiations. Ambiguity only. It will not be looked at in order for a party to show that a word meant something different than it seems like it meant on the paper. It will not be allowed to contradict a statement in the contract or to modify a statement in the contract, only for clarification. Okay. Well, now let's turn that on its head. The CISG, once again, is going to be, well, annoying. Not only does it have this unique rule that says contracts don't always have to be written, but it also has not incorporated the peril evidence rule, which is a very normal part of contract law in the United States and across the globe, really, which is another way of saying peril evidence is allowed to see the intent of the parties in all relevant circumstances and to modify or contradict parts of the contract. So if a person who is in litigation under the CISG over a sentence in the contract that says, we will sell you 16 automobiles, right? Well, a normal reader might read that sentence to say, okay, we will sell you 16 automobiles. We generally think of an automobile as a vehicle that's not a truck. So an automobile would be a sedan, convertible, a miniature car, compact car. It could be any number of things, but generally you don't use the word automobile if you're talking about semi-truck. You don't generally use the word automobile if you're talking about a box truck, right? But if one of the parties to the agreement wanted to say, well, yeah, but that's what we meant, despite our use of a word that is generally meant to interpret it, to be interpreted one way, if you look at our past negotiations, our emails back and forth as we were talking about this contract, we actually did consider automobile to mean more than just cars. Under the CISG, that would be admissible. Outside the CISG, parallel evidence rule would not have allowed that kind of modification to the normal understanding of the words. Okay? Just as an example. It'd be a really weird contract. Customs and practices. This is one thing where the CISG stays pretty true to normal contract law. Where there are gaps in a contract that just don't contemplate something that may have happened, unforeseen events that the contract did not answer with a remedy or a solution, generally those are filled in by the court just assuming normal industry standards. Okay? So they will look at past dealings and trade usage. The CISG limits this trade usage principle to two categories. They will look at, number one, the history of trade between the parties themselves, and number two, trade usages that the parties should have known were common in international trade and regularly used by the industry. This is helpful to use an example. So let's say that Company A agrees to sell Company B a spool of copper wire. Okay, a spool of copper wire. So Company B gets the shipment in, and it's a spool of copper wire. But it turns out that what it really is nickel wire that's coated with copper. Okay? Well, then they have a potential breach of contract depending on what the definition of a spool of copper wire is, right? So let's say that you're under the CISG and you go into litigation, and the court is challenged to determine this kind of gap in the contract. We never defined spool of copper wire. They're going to look at trade practice. Across the copper wire industry, how do we define a spool of copper wire? Do most companies consider nickel coated with copper to meet the definition? If they do, then that's how it's going to be interpreted in the contract for the purposes of that litigation. However, if this is highly unusual, if normally the phrase spool of copper wire means actual pure copper, then it might be interpreted the other way. Who knows? I have no idea what the copper wire industry requires. I'm just using that as an example. Okay? It's just a method of filling in the gaps of information that we might not know from the contract itself. All right. Last few things to consider here. Generally, a contract must be specific in terms of the offer and the acceptance. So some requirements for this mutual assent concept of the two parties. The offer to form a contract is required to have a few things. Number one, it must be sufficiently definite. Okay? Sufficiently definite means it must describe the goods, it must include a quantity of the goods, and it must set a price, or at the very least, it must set a scheme for pricing, such as the price will be whatever the industry rate for copper wire is on this week on this day. Okay, that's pretty normal in sales contracts, believe it or not. Another thing about the offer is it must actually propose an exchange. So there has to be bargain for consideration. You don't just offer to sell. That doesn't create a contract. Okay, you have to offer to sell for consideration. So a price, an actual trade taking place. Okay? For public offers, which are not to a specific acceptee, there is a general presumption that those are not actual offers for the purpose of contract formation. So like an advertisement, hey, come to Ben's Automotive, we're selling tires for $50 a tire, does not constitute an offer, because if you accepted that offer and then went there and they already ran out of tires, if it were a contract, you'd still be able to force them to find a tire to give you, right? And that would be bad public policy. We all know that advertisements still mean they might run out of the product by the time we get there. So we don't want to make advertisements all of a sudden become contracts. Acceptance is important. There's a phrase that happens in these situations called battle of the forms. An offer is made, and the potential acceptor of the offer says, Okay, I agree to that if you lower the price by 15%. In that hypothetical, has a contract been formed? The answer is no. You only have proper acceptance if the acceptance is a mirror image of the offer. So you might go back and forth a few times before you achieve mirror image. So offer is, I'll sell you 10 widgets for $400. And the acceptor says, okay, how about 12 widgets for $400? The offerer comes back with, okay, I'll sell you 12 widgets for $405. And finally, the acceptor says, yes, I agree to that. Only in that last exchange did you have an acceptance of a mirror image of the offer, right? So no partial acceptances would be enforced. You have to have mirror image. There's one exception to this, okay, just to make things complicated. In this battle of forms going back and forth, if the conditional acceptance is heard by the offerer, so let's just use a simple hypothetical, I'll sell you my car for $100, and the potential acceptor says, okay, I'll buy it for $90. The offeror can just go ahead and deliver the car. That is not mirror image, but it is performance, and that is implied acceptance of the counter offer. It means that you seemed like you were fine with their offer of 90, and now you're willing to perform. Okay, that can create a contract. So when the offeror performs based on the counter offer, you might have a contract. At common law, acceptance was valid at the time that the acceptance was delivered in the mail. Not delivered in the mail, I mean submitted into the chain of the mail. So let's say someone sent me an envelope and I opened it and it says, I offer to represent you in court for $200. It's an attorney mailing me here. And maybe I have some legal business that needs to be taken care of and I want to accept that. So I write a letter back. I accept your offer to represent me in court for $200, and I put it in the mailbox. In the United States, that's valid acceptance the instant that I put it in the mailbox. Okay. Under the CISG, in an international transaction, that's not the case. Acceptance only becomes valid at the time that it actually arrives back to the offeror. Okay? That might become important because if I want to somehow intercept my message to them before it gets to them, I could still keep there from being contract formation and not obligate myself, right? The seller generally has the ability to cure a breach. So if we're talking about breach of contract, the seller, the selling party, let's say they make a mistake. They agreed to sell 50 cars, and when they put them on the ship to send them across the ocean, there were only 49 of them. Well, if the buyer finds this out, and they say, oh, looks like there's only 49 cars, that does not immediately mean that a breach of contract has taken place. The seller still has time to cure so long as they beat the deadline. So maybe time's run out to ship it, maybe we'll put it on a plane and fly it over there and we'll still meet the contract deadline. That's the right to cure a breach, okay? Also, this could even be extended beyond the performance expiration date if it doesn't hurt the buyer. The term for this is called the Nachfrist period. There's not really a reason to go into why it's called that, but the so-called Nachfrist period is a period of maybe 40, 60 days or whatever after the deadline, but so long as it's not hurting the buyer, their resale value is still fine, they didn't miss out on any opportunities in business or otherwise because of the late delivery, then the contract might still be fine with no true breach, such as no penalty, okay? You could also have in those situations the option for the buyer to declare avoidance. So if they're in that so-called Nachfrist period after the expiration of the contract, when the performance was supposed to have been done, if the buyer says, we hereby declare, as a result of not meeting the deadline, this contract's null and void, and they send back the cars, and they don't send any money or payment, they do have that option, so long as the contract has technically been broken. Okay. Usually it's not used. Breaches that actually cause harm can result in compensatory damages. So, for example, I sell 500 cars for $1 million, and the buyer only sends me 900,000. I can ask for compensatory damages in the amount of the remaining 100,000. But let's go one step beyond. Let's say I had planned on investing that money, right, in a new business venture that was practically guaranteed to make me another $30,000. And since I wasn't able to invest it because you didn't give it to me, then I also lost that potential future earnings on that money. So you can also ask the court to give you damages that are reasonably foreseeable as a result of the breach, in addition to the compensatory damages. Those are called consequential damages. Okay? And we'll leave it right there. I hope this video wasn't too long, 50 minutes. Oh well. You're only getting a couple lectures a week, so I think that's fine. And these are just to help you with completing the assignments. And good luck on your one-page response. Wish you the best of luck. Contact me if there are any questions or concerns. Overall, I think everyone's doing pretty well so far. I have not noticed any major deficiencies or anybody even being particularly behind. So, so far, I'm assuming things are going good. But my phone number and my email is always available to you if you feel like you have anything you need to communicate to me. So thank you.